everyone for joining this morning. Contrary to what Zoom says, I am Carly Baker. I'm the marketing specialist for Big Sky Economic Development. Like I said, Kayla is out of town this week with the SBDC team. So I'm just facilitating this workshop for her. Real quick, for those of you who are unfamiliar with the Small Business Development Center or SBDC, it is a completely free service that we have. And the SBDC advisors do business plans. They help with financial projections and loan prep. And they offer a wide variety of trainings and workshops that are usually almost always completely free to participate in. So if you ever have any questions with your business, they're there to help you answer them or point you in the right direction to have them answered. So with that, I'll turn it over to Shane Coleman for our first of 3 intellectual property workshops.
Wonderful. Well, thank you. And I'm sorry we're missing out on some of the folks. Let me know if I'm not as, I see Nikki Shovel just joined. Hi, Nikki. Not that familiar with Zoom, so bear with me, please, as I try to share my screen. Again, my name is Shane Coleman. I'm a patent attorney here in Montana. Being in Montana, my practice is fairly broad. I mostly do litigation. When it comes to patent work, I do all types. In fact, I do copyright, trademark, trade secret, and general commercial litigation as well, just given the nature of businesses in the area. That's unlike other places where perhaps people are a little more specialized. What I want to try to do is share my screen. So here's what we're going to try to talk about today. Let me, where'd we go here? There we go. Okay, that's popped up all sorts of places now for me. What we're going to talk about today is, this is the first of 3 seminars. This is kind of an overview. I'm going to talk about intellectual property generally, and specifically the objectives for today are to try to understand what might be protected that a small business might own, and how do you go about protecting that. And I apologize, the sun came out just as I started this. Let me close my blind behind me here so it's not such a distraction, or any more of one that it otherwise would be. So when we talk about a business owning property, we're generally, people are familiar with different types of property. Real property, we're talking about land, we're talking about a headquarters building, perhaps an office building, an industrial facility built, or other improvements on bare land. Businesses also have personal property. We're talking about office equipment, computers, furniture, desks, etc. Today, where this fits in is a third category of generally intangible personal property that you can't see and touch, if you will. And that's what intellectual property is. It's a subset of intangible property. We're talking primarily about things like technologies, formulas, to some extent brands, logos, designs, photographs in certain industries. We're talking about music and other things a little more mundane, like customer data. Business pricing information, for example, might be the sort of thing that might be able to be protected in certain businesses under certain circumstances. And that's what I'm going to run through today and in the next couple of weeks as well. So what is intellectual property? What specifically are we talking about? Generally, and this is a broad overstatement, but generally there's 4 types of intellectual property that we're normally discussing more than others. Patents, of course, are, there's 3 different types of patents we'll get to in a minute, but in general, you should be thinking about a patent if you've got some sort of a product or some sort of a process that is unique, has not been done before. You're selling a widget through your store that you've manufactured that no one else has come up with. You're manufacturing a widget using a special technique or process that nobody else has used. You've come up with software code, perhaps, that performs this method inside a computer, likewise, that's the sort of thing, generally speaking, that a patent, a utility patent in particular, will cover. Copyrights, and I've kind of lumped, for our next presentation next week, I've kind of lumped copyrights and patents together. That sort of makes sense, it sort of doesn't. But copyrights can be somewhat varied. They cover, essentially, think of it as an artistic expression that has been put into some sort of media, if you will. It's text is an obvious one, books and other printed text, artwork, music, software can be. For a small business owner, the types of things that we typically see in Montana that someone wants to protect. I mean, we do occasionally have musicians and artists who that's the core of their business. But other more common businesses are, if you've got a particularly interesting logo that might serve as a trademark also, it's conceivable that could be protected with a copyright. If you have printed material on your website, or some sort of a graphical user interface on a website, that's the sort of thing that can be protected in a lot of instances with a copyright, and it may make sense to do that. On the more mundane side of things, if you will, and I see this somewhat on the litigation front, where I see copyrights a lot of times are local businesses infringing someone's copyright, and it may be what we're talking about, a so-called copyright troll. We'll get into that more next week, but these are people who, maybe unknowingly do nothing more than operate a retail business and play the radio. That's not allowed. You owe a copyright royalty to every artist whose songs appeared on the radio. Frequently, probably 5 times a year, we get calls from someone who found an interesting photograph on a website, maybe even a website that encouraged the use of the photograph. They put it on their own website. They used it internally for some of their own purposes, and then they're wondering why they're getting a demand letter for infringing that image. And the short answer, the pithy answer, is just because you see it on the internet doesn't mean you can take it. And just because somebody encourages you to use their image doesn't mean they're encouraging you to use it for free. Finally, the other area I see a lot of in Montana are just routine software. And software is something that you may or may not want to protect with a copyright. It's normally we're talking about the object code and not not the source code, but it depends what you're dealing with. But a typical company that operates, say they sell a software product or an app, they could get a copyright for the text, the code, if you will, that goes into that application, that software product, and also for whatever sort of graphical user interface might be spit out to the user who's using that, whether it's a retail user or more of a back-end user, if you will. Trademarks are the next area we're going to talk about. Trademarks are a little bit different than copyrights and patents in that they arise under statute and not, they arise under the Commerce Clause, effectively, of the Constitution, but they're creatures of statute that Congress could get rid of at any time. Copyrights and patents, on the other hand, are subject to lots and lots of statutes, but they also originate right in the Constitution. Says Congress shall make laws to protect those areas. No such thing exists for trademarks. Trademark is, think of it as a brand. It's a source identifier. It's obviously, McDonald's, the restaurant, has a trademark for its restaurant services. They also have a registered trademark for the Big Mac, a product that they sell. When you see the golden arches or the word McDonald's or Big Mac, you know what you're getting. Whether you like that or not, you know that it comes from the McDonald's Corporation. And that's the whole purpose of a trademark. A trademark is some sort of distinguishing mark that's affiliated with some sort of goods and services. It's not a race to the trademark office like, arguably the patents and copyrights have some benefit to being the first person there. It's based instead on somebody's actual use of the mark. And while it's important to use it first, you have to actually use it. You know, a patent, you can tie up the rights to a particular invention without actually ever making or using the invention. A copyright, you can, you know, design a beautiful work of art, or a, I apologize again, the sun's moving on me here. Or, you know, write your own software code, but there's no requirement that you have to use it for someone to infringe it. That's in contrast to trademark. Trademark is more a concept of commerce, where if you use it and people associate the mark with your business or the mark with your product, that's where the protection lies. The fourth area we'll talk about a lot are trade secrets. They are exactly what they sound like. They are things that are secret. They are things that derive independent economic value from the fact that they're secret, from the fact that they're not generally well known. That this protects things like, you know, the glaring examples are the Coca-Cola formula, any number of different top secret formula that are used by industry. But on again, the more mundane side that we see more commonly in Montana, it's possible that it covers business and financial plans. It's possible that it covers customer lists under certain circumstances. They are things that somebody cannot figure out because they're secret. And once they are no longer secret, they are no longer protected. That's the double-edged sword we'll talk about later here. Just looking at these generally, this is what they are. The question is, how do you go about protecting them? And in the broadest sense, patents only exist if some sort of a patent application is filed with the federal government. Copyrights exist from the moment they're created, but the copyright holder has no real rights to go to court or otherwise enforce the copyrights without registering something again with the federal government. Trademarks exist at common law from the moment you've used them, but for practical purposes, they need to be registered, and they can be registered at the state or federal level, but for all intents and purposes, they need to be registered at the federal level to confer any sort of rights. Trade secrets, and again, this is why it becomes an outlier, are the only one of these that has no registration process. The very nature of a trade secret is it's secret. That means it's secret even from the government. Nobody knows about it. It's difficult to determine. And so as a result, we don't register any of those. We're going to take these one at a time, starting with patents. Patents, as I mentioned before, there's three types. I'm primarily talking about utility patents. I don't have any graph for this slide. I probably should, but if I were speculating, I would say 95% of all patents that are issued or filed as applications are utility patents. These are things that protect the function of a product. Specifically, there's four types of things that could be covered by a utility patent. It's a process, a method of some sort, a machine, which is exactly what it sounds like, something that's tangible and does something, a manufacture, which is an awkward term these days, but it means essentially an article of manufacture that's different than the machine itself, and a composition of materials. Those are the four categories, and broadly speaking, those four categories encompass just about anything that is a functional product, if you will, or service. Anything that meets one of those categories also needs to be new and useful. It's very easy to prove that things are useful. It's more difficult to prove that things are truly new, and that's where the real action is in obtaining a patent. Second, we have design patents. Design patents cover certain ornamental designs. I deal with design patents, like I say, a lot less frequently than utility patents, but they do exist. You could get a design patent on a building, on the the overall look of it. You could get a design patent on a box. I see that very frequently. Actually, I've done, oddly enough, dealt with a lot of design patents on a lot of display boxes. And they can be very valuable. On sneakers, in some instances, a design patent is something that can protect certain aspects of the sneaker. The key to the design patents, and we'll get into that probably in greater detail next week, but design patents by definition cannot cover any utilitarian function of the product. They cover only what it looks like. In other words, if a certain feature performs a certain function, and that's why it's there, it's not a monopoly on the use of that function. If you want a monopoly on anything we talk about today or for the next couple of weeks looking at these, the only way you obtain a monopoly on something functional is through a utility patent. Design patent only covers the design. It overlaps significantly with a copyright on a visual art of the product in an awful lot of cases. And then finally, we have plant patents. That is not something that I'm guessing anybody in Montana or on this presentation deals with. I've only had one lawsuit in my life involving plants. They cover only certain types of asexually reproduced new and distinct plants. Think fruit trees, roses. Those are, I would bet the two of those compose 50% of all of the plant patents that anybody cares about, at least. The case I had many years ago involved patents on table grapes, and it was not based in Montana. These are very significant, but they're very significant to niche industries. They're not something that we see up here in Montana much. And it's not, for whatever it's worth, it does not cover all plants if you're trying to create your own new and asexually reproduced distinct plants. It only covers certain types which are more narrowly defined. So what we're really talking about when we talk about patents is we're talking about utility patents. Utility patents protect ideas, processes, inventions. What a patent is it's the right to exclude others from making, using, selling, or importing a particular patented invention or offering to do any of those same things. It is not significantly the right to actually make the product, use the product, sell the product, or import the product. It's the right to find somebody who is infringing the invention, take that person to federal court, and try to extract damages from them, or try to get an injunction that prevents them from continuing to make, use, sell, import that particular inventive process or invention. It's a limited monopoly, in other words. It's a monopoly created by statute for a period of 20 years from the date the application is filed, in exchange for the inventor disclosing everything that he or she knows about the invention, the best way to make it a sufficient description that somebody who's fairly smart can look at the patent application, which becomes the patent, and go out and make and use the invention. That's in exchange for that disclosure to the public, committing that invention to the public domain long term, the inventor gets a monopoly for a period of time. That's 20 years from the date the application is filed. Previously, and I feel like I'm dating myself now because it was a good 20 plus years ago, but previously it was 17 years from the date of issuance of the patent. And the reason we got to 20 years, for whatever it's worth, is for a simple invention that sailed through the patent office, 3 years is about the period of time it takes. It's a long process, it's an expensive process, but when Congress changed the law in 1999, it concluded that patents could get through in a lot of instances in 3 years, and that's how we got to 20, for whatever that's worth. It is possible for patents to be extended on a patent by patent basis, It happens frequently, but it's not normally for more than a couple of years if things are ridiculously delayed at the patent office. So turning then to the requirements to obtain a utility patent. As I mentioned before, the patent needs to be useful. That's not a point of contention. I'm certain there are cases out there. I know there are cases out there from long ago that talk about the usefulness of an invention, but that's not something that the patent office normally considers. What the patent office considers, where all of the action is in the context of, is it novel? And is it non-obvious? So novelty means nobody has, in the broad sense, made that invention before, if that makes sense. Nobody no one has made that exact product that's being claimed or that exact method in this exact same manner. And that's usually pretty easy to overcome. Non-obviousness means the invention is not simply an obvious variation of something in the prior art, or an obvious combination of one or more prior art references, if you will, and I've got a slide coming up on what that is. But what it means is, you haven't simply, if you've invented a table, for instance, and it was previously known to have a flat surface and legs were previously known, it would be obvious to combine the legs with the table. That's what the patent office might say. The other requirements, and this actually fits within the novelty and non-obviousness, but it needs to be called out specifically, is the so-called statutory bars. And the statutory bar means in the United States, you have 1 year from the date that the patent is first filed or first disclosed, if you will, and I'll get into that more in a minute, before you need to file an application. If you disclose this in a printed publication, you've come up with a great idea, and you disclose it to any number of people not under a confidentiality agreement, or you offer to sell it. And when I say sell it, I mean either sell the product that embodies the invention or try to sell the inventive rights themselves. You have 1 year from that point to try to get an application, or to get an application on file, and then it'll proceed for, like I say, on average about 3 years. If you do not do that in the United States within 1 year of whenever you first sold it, you forever waived your patent rights. And the idea is, the public policy behind that is, you can't test the waters, if you will, have a great product, sell it for years on retail shelves, say it's a widget, and then after the entire industry has copied what you're doing, go and try to get a patent on it. You can't do that. You have a 1 year period, again, in the United States to do that. In the vast majority of other countries, there is no 1 year grace period. So let's combine these two things into a practical scenario that we see all the time. There's frequently we have a client that comes to us with, they've got a trade show coming up, or they have a trade show that just occurred. They have a booth there, they have a product that may or may not be finalized, but they want to sell that product, and they're advertising it there. If, in the United States, they have 1 year from that very first disclosure, if that is the first disclosure, to file some sort of a patent application. And if they don't, that individual waives his or her rights forever. Hypothetically, if that same individual wants to seek protection in Europe or the vast majority of other countries, those rights are waived the second the trade show occurs without an application on file. In other words, Europe and the vast majority of other countries do not recognize this 1 year statutory bar. It's an absolute bar. So that needs to be, you need to get that on file, otherwise the application is abandoned.
Hey, Shane.
Yeah.
Sorry to interrupt. I just got a message in the chat that the screen that you're sharing is only, it has stayed on the first title slide.
Oh, you're kidding.
So
Okay. That's not helpful. Well, it's helpful to know it now. Okay, let me try to unshare and share. What do you see now?
I still just see the title slide.
It's not changing as I do any of.
No. Try, if you could stop sharing and then try resharing again. We'll see if that works.
What's being, is that the title slide there you're seeing again?
Yep. Oh, there, now it changed.
Changed a little. Okay, I apologize for that. I don't know what I think I was sharing the wrong. Nope. What do you see now?
It says types of property. Maybe try clicking through there and see if it moves.
Yeah, I may need to just show it on the screen that you see here with, that's strange, but that's my problem. I apologize.
Oh no, sorry, I didn't catch that earlier.
Does it say types of property or types of?
Types of patents.
Types of patents? Okay. I will probably just share this then. I for whatever reason, the other one I'm looking at has been following along nicely for me. Okay, so I apologize. We were talking about utility patents. This is the slide I was on. If it, for whatever it's worth, I did not make it very far through the slide deck. We were talking about utility patents. We were talking about how they need to be novel, non-obvious, and useful. That the real action is with, you know, is this invention something that's just an obvious variation of the so-called prior art, or is it simply an obvious combination of multiple so-called prior art references? And concluding that, this actually ties into the definition of prior art, but things become prior art if they're not, if the application, even if it's, or the invention rather, even if it's disclosed by the inventor more than a year before the application is filed, that is prior art. The inventor's own conduct is prior art. So we need to get the application on file. The takeaway, I tell people, if you know, learn nothing else about patents, the takeaway is should be that they're expensive and time consuming to get. It's the only way to protect the actual function of what you're doing. Any other way to try to protect the functionality will fail. And then counterbalanced with that is you need to make a decision fairly quickly. You need to make a decision within 1 year of whenever you first disclose the invention. I use that term deliberately, broadly, ambiguously, because there's a lot of things that amount to disclosure and things that don't. So types of of applications, rather. When I say you need to file an application to preserve your rights, say within the 1 year statutory period, or just to otherwise protect your rights, you can preserve your rights by filing 3 types of applications: a so-called provisional application, a non-provisional application, which is a normal application, or a foreign application filed in certain other countries or regions of countries that are subject to the so-called Patent Cooperation Treaty, the PCT. Let's actually start with the middle one of those 3 there, non-provisional applications. This is a normal application today. When I talk about a patent application, I'm talking about a non-provisional United States patent application. And what these are this is what becomes the patent. There's not, unlike other areas of the law, there's not some form that you fill out to get a patent. I mean, actually there are dozens of forms, but the thing that becomes the patent itself, the so-called patent application, is drafted from whole cloth. This is where the inventor tells the patent office, this is my invention. That gets filed with the patent office. It gets examined by a patent examiner who is assigned to that particular art unit, who then sends back, there's an exchange of arguments back and forth. The patent is, ultimately allowed, rejected, modified, et cetera, through them. That's a normal non-provisional patent application. And just to put some brackets around some of these things in terms of dollars, years ago, a client asked me what a patent costs, and the pithy answer is it costs the same as a car. How much does a car cost, and what kind of a car are you looking for? But they're, fairly in those ranges, or at least they used to be. A fairly simple patent is going to run you $8,000 to $12,000 or $15,000, including all the filing fees. So then we've got above that a provisional application. A provisional application is a holding spot, if you will, a bookmark that tells the patent office, hey, I've got something here. I'm going to claim a patent on it, or I might, but I just wanted to get it on file now. And what it does, it sits on a shelf, an electronic shelf these days, and does nothing. It will never get examined. It will never become a patent. It cannot be. It's a strange nuance of international law, but what it can do is it's a lot less expensive to file one of these as a placeholder than it is to file a full-blown non-provisional patent application. And for instance, if we have I've had this scenario years ago, we have a client running off to a trade show and wants to get something on file so the client can write patent pending on the literature, or more likely has already marked the literature patent pending. And we crank out kind of a quick and dirty patent application that doesn't have to meet all of the requirements of a formal, regular, non-provisional application. That provisional application then lasts for 1 year, and sometime before that 1 year period lapses, the inventor needs to file a non-provisional application, or otherwise all the patent rights are forfeited, for the most part, assuming it's been disclosed. It needs to be perfected, if you will, with a real application, a non-provisional application. And then finally, we have foreign applications. It is possible there's no such thing as a foreign patent, or a worldwide patent, or a European patent even, or an Asian patent. It's country by country, or state by state, as they're referred to in the treaty. There are common places where, if you're looking for patent protection in a multitude of jurisdictions, countries, where you can file a so-called Patent Cooperation Treaty, PCT, application with one of the PCT receiving offices. The United States Patent and Trademark Office is one such receiving office. That's an incredibly expensive process. And then from the PCT, the idea is it streamlines the examination process, because even though the patent laws vary country to country, there are a lot of commonalities. In general, countries don't let you protect something that somebody else came up with first, in the simplest sense. And so you'll get a common search report and a few other things that let you modify the application as it goes through. And then ultimately, you've got to drop down from the so-called international phase into the national phase by dropping into the European Union system, and then dropping into its individual constituent countries that you want protection in, or going right from the international stage to particular countries. That's the PCT process. It's incredibly expensive. If the overall process to get a U.S. patent application is $10,000 to $15,000, most of our clients that we talk to, if you're going to try to seek protection in most of Europe, Canada, Australia are the most common places, we normally say just add a zero to the end of that. It's a very expensive proposition. It's not something to be undertaken lightly, and our clients do it daily, but our clients tend to be bigger and not Montana based for the most part. It's also possible to go directly into Canada from the United States and vice versa. You can file an application here and only file one in Canada. It sounds a little bit strange, but at least years ago, sometimes people kind of forgot that Canada was a different country when their product, when their inventions, even here in Montana, involve something like, agricultural machinery, oil and gas production technology, that sort of thing. There's a lot of cross-border business being done by relatively small companies, and we file an awful lot of those. And for whatever reason, there's a lot of reasons why, but over the years, Australia has always been a pretty common other place to file, in addition to Europe. So the process generally, and I've touched on this a little bit, but from here on out, I'm talking about normal, so-called non-provisional US applications. You file the application. We then go through a period of so-called prosecution of the application. We don't mean enforcing it against third parties. We mean prosecuting its issuance through the patent office. And what this means is if everything goes in a simple and streamlined manner, the patent applicant receives a patent office action from the patent office. 9 times out of 10, the office action rejects the entirety of the patent. The application then, or the applicant rather, then amends the application to meet the inventor, meet the examiner's concerns, argues with the examiner like a, kind of a legal brief, if you will, why the examiner's wrong, or does some combination of both. And usually it's some combination of both. It's vaguely like filing a legal brief, except the judge is also your adversary in some respects. So it's a little more diplomatic than the adversarial process of litigation. If everything goes well, then after a period of time, the patent office will issue a so-called notice of allowance, meaning the patent will issue into something, and ultimately the patent will issue. To again put some time frames around this, from the day the application is filed, the applicant's probably looking at about somewhere between 6 months at the earliest to 12 months, is not an outside time frame before the patent examiner even looks at it. That's just the process in Washington. It's about well, and now they're spread out around the country, but it's about a year-long process before anybody really even looks at this or does anything. If everything goes well from filing to issuance, you're looking at about a 3-year process, and it easily could be longer if you're fighting for greater protection. Some examples of a utility patent, just so you can see it. These are, it's tempting to look at mechanical devices, something I can see and touch, by just simply looking at the drawings. That, of course, is just one type of patent, and that, of course, is just that the drawings do not define what the invention is, but it gives you some idea at first glance what it might be. What you've got here is the invention by Mr. Rubik for his cube, an interspatial or a spatial logical toy. And so what you can generally glean from an example utility patent, and we'll get into this invention in greater detail next time, but just by way of an overview, you've got an abstract that describes generally what the patent is all about, how it fits into the world of every other invention. As you can see here, this is the 4 million plus patent issued by the US Patent Office by the number at the top. You've got some drawings, all sorts of cross sections and other drawings about how the Rubik's Cube looks. And then you've got pages and pages and pages that are not shown here that go on in great textual detail describing how a Rubik's Cube works. And, somewhat significantly, he claimed this originally as not necessarily requiring that it be a 3 by 3 by 3 cube, that it could be that there's other embodiments shown that are the commercial embodiment with a 3 by 3 by 3 cube. But the patent is broader than that. It doesn't necessarily require that it look exactly like that. And it just, in broad sense, if I claim a Rubik's Cube with, 3 by 3 on one side and 2 by 3 on the other 4 sides, or the adjacent sides rather, that necessarily covers one that has 3 by 3 on one and 3 by 3 on all the others. It's like if I claim a table with 3 legs and someone makes one with 4 legs, that 4-legged table also has 3 legs and therefore infringes mine. If someone made a 2-legged table, not a very good table, it would not infringe mine because I've claimed one that has 3 legs. A 4-legged table has 3, a 2-legged table does not have 3. Just by way of further example of a design patent. So in a design patent, there really is very little text. It comes down to a series of designs. This is a exercise device is the official title of our shake weight, if someone remembers these from infomercials years ago. It's the overall shape of a dumbbell, I guess, but they're not claiming here significantly the way one shakes the shake weight side to side. That's a functional feature, but what they are claiming is the overall shape and design of it. Finally, examples of some plant patents, and these are nothing more than some photos taken from the patent office's website, but these are different types of plant patents that have issued long ago. In the one case, 1938 for the peach tree, plant patent number 271. These very, very old. So summing up patents, and that is, like I say, this is the only way you can protect the functionality of anything. They can be incredibly valuable. They give you a monopoly to make the product, or at least exclude others from making the product. They keep others from making it. They keep others from making articles that are made using a patented process, if that's what the patent is on. They keep others from selling it or offering to sell it. They keep others from importing it. So why do we care about all those different things? It's easy to imagine somebody across the street, you get a patent on your widget, the person across the street sells the same widget. That they make it, they sell it, and you go sue them. That's your typical case, perhaps. But in other cases, let's say you've got a method of using it. Let's say you've got a software code method. Whoever the end user is, in the case of software code, usually that's the retail customer whoever executes those instructions to cause the computer to do something is the infringer. They're using it. If you invented a shovel and you claim not only the features of the shovel but a method of shoveling, you can sue. You could sue Ace Hardware for selling your shovel. You can also sue every individual homeowner who bought a $12 shovel and is shoveling in their backyard. There's obvious problems and advantages to doing that, but you can sue both of them. Say it's being sold by, you don't know who's making it, but it's being sold by Ace. Well, they're now selling it as well. Even if they don't manufacture it, if they're simply selling an infringing article, that is something prohibited by the patent law if it infringes. And then finally, importing. And this is your fairly typical case of something being made abroad and being imported to the United States. You can sue you can sue whoever the receiving company is. And more importantly, setting aside all of the court remedies, in the importation context, you can file a claim as the patent holder with the International Trade Commission and seek the impoundment of goods that are being, infringing goods that are being impounded or imported to the United States. The final advantage, I guess, of a patent is, I touched on this just briefly, but it's so-called strict liability. The infringing party does not need to know that he or she is infringing the patent. If they make, use, sell, import, offer to do any of those things, a patented invention, that person has infringed and they're on the hook for damages, which we'll get to later. The disadvantages of getting a patent. The inventor does need to register, file the application with the patent office. The inventor, if you don't do it within a year, you've blown those rights. The rights are limited. Frankly, 20 years from the date of filing is pretty long for most inventions, but it depends. In the context of software, the software methods are probably not going to be used after 20 years if they're patentable in the first place. In the context of a regulated product like a drug or some other medical composition that's subject to other layers of of government scrutiny before it can even be sold. You know, the drug might not even hit the market until 12 years after it's patented due to other testing requirements and government approvals. So depending what it is, 20 years might be a lot or might be a little. And then finally, in order to enforce it, you do need to defend it, the patent, not only to prove that somebody's infringed it, but a patent holder that goes to court can expect to get a counterclaim that the patent is invalid. That's just how the patents work. And on average, to get a patent issued, the patent examiner can spend about 10 hours searching for the so-called prior art that might invalidate your patent. Fast forward now, and that's what happens when your patent is issued at the patent office. Fast forward to a few years out where the patent is now the source of millions of dollars in revenue. The infringer, who's made millions of dollars, can afford to spend a lot more than 10 hours on lawyers and other people searching different places for prior art to try to invalidate it. So that will happen in just about every patent case. Moving on then to copyrights. As I mentioned briefly at the outset, copyrights cover original works of authorship. These are, think books, music, art. Copying is required to prove copyright infringement. So in theory, if somebody independently creates the identical thing and can prove that in court, it's not like patent law. It's not strict liability. But independent creation is absolutely a defense to copyright. Independent creation does not arise in a lot of contexts. In most cases, we see actual copying. Very rarely do we have somebody copy software code who hasn't, who says, no, I independently created it, because there's just too much, there's too much information we can find in discovery in litigation that shows what exactly was copied, even if they displayed it on their screen, looked at it, typed up new code, which is unlikely. Where it comes up, the independent creation thing is more when someone is trying to claim a copyright on the Disney movies get sued every single time for these. Someone sent in a screenplay for a Disney cartoon movie that looks a lot like whatever the one that came out this week, and I'm getting my studios mixed up, but I know the Finding Nemo movies all had people claiming that they invented the concept of the fish with the disabled wing, or fin rather. Before that, sent it off to Pixar, Disney, or whomever, and and that Disney says, no, we created it independently of that. That's where that comes up. So in copyrights, though, I touched on this at the outset too, I guess, but copyrights are automatically applied to any original work from the moment of creation. And it's counterintuitive, though, but in order to actually bring suit and enforce the rights, the copyright needs to be registered with the Library of Congress, the U.S. Copyright Office in particular. That's a really basic process. So unlike our patent process, that was going to take 3 or 4 years and be examined and rejected and all of that, this looks a little bit like recording a deed to your property or a mortgage on a house. You send it in with the filing fee. I actually don't know if the $35 to $55 is still accurate, but it's somewhere in that range. The Copyright Office looks at it. If it looks like the form was filled out correctly and it's not a long form, it's a very simple form, they'll stamp it, file it. It still takes about 6 months to issue, but it's a rubber stamp process. It's not just like the clerk and recorder is not going to, scrutinize your deed to make sure that you really do own the property and that the fence boundaries are really accurately described in the deed grant language. The Copyright Office is not going to scrutinize whether you're actually the first inventor. That's not, or first author rather, of it. Other big time bullet points, I guess, for copyrights, there are so-called statutory damages. If somebody infringes your copyright after you've registered it, the copyright holder can recover attorney's fees and so-called statutory damages. And what that means is it's in the range of $500 to $30,000 per work that has been infringed. So if someone has taken your artwork, put it on their website, they took 3 of them, you could go to court and argue for collecting $90,000 from them. And a jury might agree with you, or a jury might give you $1,500. That's the kind of range we're looking at. You can also get your actual damages, but statutory damages, you know, a lot of times people steal a copyright and don't ever make any money off of it. Or if they do, you can't prove what they made. It's tenuous to the profits they derived. So the copyright holder can elect to obtain statutory damages when they can't otherwise figure out what actual damages are. And that can be quite valuable depending what was taken. Finally, copyrights are limited, but for practical purposes, they're not limited. They've got limits for the most part of the author's life plus a period of years. 70 years is the current one, I believe. Cynically, the period keeps getting extended by Congress. It was 25, it was life of the author plus 25 years. Then it was life of the author plus 50, and then life of the author plus 70. They're tracking, again, this is a cynical view, but there's an old Steamboat Willie cartoon, Mickey Mouse, that dates back to a very long period of time. And even though Disney holds, you know, thousands of copyrights and trademarks and everything else on Disney characters, there's one out there that is the subject of their lobbying efforts, and they want to make sure that does not enter the public domain. So for practical purposes, copyrights are around for a very, very long time. So what can be covered by a copyright registration? I talked about some of these already, but think about books, magazines, certain types of business plans if they're original. Your website is probably one of the most common things we see people register. I've had a case within the last month or so where somebody's client took their website, decided to compete with them, and wholesale copied everything. I mean, like word for word on the website, what they do. They change the name, but that's it. Drawings, architectural drawings, for instance, and other drawings can be copyrighted. Photographs, of course, movies, music, sculpture. Sculpture is where you see overlap with design patents. They're different creatures. They have different processes for obtaining them. They cover different things. They're enforced differently. They provide different remedies, but they can cover overlapping subject matter. And finally, fashion. To the extent that a product is not functional, copyrights will never cover the functional features of a product. But so maybe you can't get a visual art copyright on a particular thing that's been created, but you can probably still get, and again, I've had this lawsuit in federal court here as well, where the actual product could not be protected with copyrights, but the drawings of the product that were then used to make the product could be, at least according to our judge. And then finally, even email. So if you've got lengthy emails that somebody has stolen from you, they can be copyrighted. What exactly is a copyright? What does it protect? It grants the author the right to, obviously, or not obviously, reproduce the work, make copies of it, to prepare derivative works. What's a derivative work? It's something that modifies ever so slightly the original work into something else. Classic examples would be transforming a visual art, something that's been registered as a three-dimensional sculpture into a photograph or into a drawing. And depending how it's been registered, you may not be able to do that. It's the right to distribute copies, to not only make them, but to distribute them. In certain instances, depending what the work is, it may include the right to perform the work publicly or display it publicly. So if you have the sculptural rights, for instance, you're the only one that can display those. If you have the performance rights of music composition or whatever, you're the only one that can perform those rights. But again, what we see for the most part is people protecting their websites that their customers interact with, and people protecting their designs and logos, and then to a lesser extent, problems that people have with internet trolls, as we'll call them, when they misuse somebody else's photograph from the internet. How do we protect it? Again, it's the moment the copyright is actually in physical form, reduced to some sort of a medium, it's protected, but it does need to be registered with the Library of Congress. The difference largely is when can you start collecting damages. Whether you have registered it or not with the Library of Congress, and you should, because it's a simple and cheap process, you should include a copyright notice. Copyright notice needs three things. It needs the Circle C, or the word copyright, or COPY period, something close to that. It needs the, it needs the year of creation or publication, and it needs the name of the owner. And that doesn't need to be the name of the author. It can be if the company owns it, like your website should say at the bottom, the current year, whenever it was most recently modified, copyright this year, your company's name. This informs the public that the work has been protected. It tells the public who the owner of the potentially protected work is. It designates a year when we can go back and say, on this date, we claimed it was protected. It's very helpful to prove in some instances you can get damages for willful infringement if we can show that they had access to it and they're given notice of the copyright. Copyrights have a ton of information available on the internet, copyrights.gov. It's a very straightforward process. That said, every year we get a few clients where we're cleaning up what they thought they filed because it wasn't done right, but it is a fairly straightforward process, certainly compared to patents and trademarks. So the advantages of a copyright, it's automatic. The protection and some level of protection is automatic. Registering it is a very inexpensive process, and they are exclusive rights. You can have all of that list of exclusive rights, and I didn't list all of them, that attend to copyright registrations. The limitations on it, there is this time limitation of that varies based on whether it's published or not, but it's a very, very long time period. It does not protect against independent creation, which is rare, but it does occur. And probably most importantly, a copyright cannot ever, under any circumstances, protect functional features of a product. Only patents can do that, nor can it protect abstract ideas. The abstract idea of the fish with an injured fin swimming around in the ocean looking for his father. It can't be, that vague idea in that vaguest context is not something that can be protected. Moving on then to trademarks and service marks. And again, what is a trademark? It's something that identifies a source. So a lot of people have a misconception that it's about running to the trademark office and obtaining some sort of rights before anybody else uses the word or phrase, and they can tie it up for all time, for all purposes. That's not exactly it, and it's actually a far cry from that, but it's a source identifier. So there's two parts to it. There's the mark, McDonald's, and there's goods or services that attend to that mark, food or food and restaurant services, and in McDonald's case, 1,000 other items, I'm sure. But it needs to be both, and you know, because of that, we can have, you can have multiple trademark holders of the same general mark in different fields. Think Delta Airlines, Delta Power Tools, Delta Faucets, all major retail companies, all with huge marketing presences, all coexisting without anybody being confused. The question about whether somebody infringes a trademark is, are consumers likely to be confused when they see Delta Power Tools and Delta Airlines? Is one likely to think that Delta Airlines got into the business of making utility saws? Probably not, you know, for historic reasons and other reasons, but that is fundamentally the question. Trademark is there to identify the source. Technically, there's three types of trademark registration that I'll blow through. There is a common law trademark rights that exist from the moment you've used the mark. Again, these are only enforceable in extraordinarily limited circumstances. We see them a lot in Montana because people forgot and didn't bother to register their mark. They will ultimately be limited to whatever geographic area, in the case of most businesses, where it was originally used. They're not terribly valuable. Common law trademark claims are filed only when we see when someone didn't properly register it. State registration is a very simple process. Every state has a state trademark registration process. In Montana, that's filed with the Secretary of State. It only provides protection within the state where it's registered. But more importantly, it's subject to federal registration rights. So trademark registrations are cheap. I think they were $30 the last time I looked at them, 20 or 30. They're worth every bit of that, but they're not worth a lot more. The real action is in the federal registration, and that's going to be a couple $1,000 to file at a minimum. It's filed with the United States Patent and Trademark Office. It creates a presumption that the mark is used in all 50 states. So if other people are using the mark, the same mark, the identical mark for the identical services or goods before you, every one of those prior uses is geographically locked or locked in otherwise to whatever trade channels they were using before the registration. So the real action, of course, is in federal, at the Federal Trademark Office. Trademarks versus trade names, they're very similar. They're often confused. There's no substantive difference. Trademarks simply denote the source of goods or the source of services. They're for the purpose of brand development. Trade names, oftentimes in Montana, are the first trademarks that people file. These are, oftentimes just the business that or the name under which the company does business, if that makes sense. McDonald's first trademark might have been McDonald's rather than the Quarter Pounder or the Big Mac. And these are, here's where I guess where the interplay comes in is in Montana, and I looked at this for a client just a couple of days ago, and in some other states, if you go to file a trademark application, the Secretary of State may check the trademark application name against their list of corporate names in the state and assumed business names. Corporate names are not business names or are not trademarks. Assumed business names are not trademarks. They might prevent someone from getting the same name, but in most cases they don't. The issue I had the other day was client wanted to start using a name. There are no fewer than probably 50 or 60 other businesses in Montana with the same name, even though it's a somewhat creative name, but none of them are in the same field. None of them would be deemed competitors. None of them provide the same services, and none of them, not one of those 50 plus others, had filed a trademark registration. In those cases, the trademark office or the Secretary of State's office, rather, in Montana handling this really doesn't necessarily process them correctly. But you should know that if you're going to try to register your business name as an assumed business name or a corporate name, you should also think about trying to register a trademark, if only to do it cheaply at the state level, because it might keep someone else from stealing your trademark, which happens frequently. Trademarks can think expansively. It doesn't need to be words, numbers. It doesn't need to be a logo. It can be colors, it can be packaging, it can be sounds and smells, and there are successfully registered marks of every one of these. They can be moving images in some cases. Trademarks and service marks are essentially the same thing. One just denotes goods, the other denotes the source of services. These are some examples of trade dress, which can be registered or can be unregistered trade dress. And again, there's different types. I believe every one that you're looking at here on this slide are actually registered trademarks at trade dress technically. But the shape of the Volkswagen Beetle, the red wax on the Maker's Mark whiskey bottle, bourbon bottle, the Coca-Cola bottle, the red tab on the Levi's jeans, the pink color of insulation is coming from Owens Corning. The red on the bottom of the whoever makes the Vuitton shoes have all been upheld in court as being valid registered trade dress. Performs the same function Apparently, when someone buys a pair of shoes with red on the bottoms, they know that they're coming from a particular source. I did not know that till I put this presentation together years ago. And likewise with the Beetle, when you see that shape of a car, you know that it's a Volkswagen. That's why it's protected. Advantages of a trademark. Trademarks are fairly inexpensive. You're going to be all in a few $1,000s to get it registered. Potentially a trademark can last in perpetuity. It can last as long as you keep paying registration fees, and they come up at different intervals throughout the life of it. You have to prove that you've continued to use the mark in commerce, you've continued to sell goods or services under that mark. And they cover areas that are not going to be protected by other types of intellectual property. The red color on shoes is not going to be subject to a copyright because it's not sufficiently creative. It's not going to be subject to a utility patent because it performs no function. It's not going to be subject to a trade secret because these are retail products sold everywhere. Everybody sees them. And the same could be said of every other trademark we looked at. None of them are secret. By definition, they're the opposite of secret. And they have lots of potential time periods when they could be used. The drawbacks are you need to keep using them. It's not this system where you lock up a phrase and then hope people infringe and you sue them. You have to actually sell goods or services under it. The other drawback is they can have limited protection. They're never going to protect the functionality of something, and we'll get in greater detail with the third in this series talking about what some functional marks are. And believe me, there's a lot of things that might actually perform a function, and trademarks can never take the place of a patent in that regard. Finally, then let's turn to trade secrets, and then if time permits, I want to go through answer questions, or I've got a few hypotheticals to show the interplay. Trade secrets are, as I said, things that are not generally known that confer some sort of economic benefit on the owner as a result of not being generally known, and which the owner has taken reasonable efforts to keep secret. So the things we look at are something that it's one of these things where trade secrets are easy to allege but difficult to prove. To what extent has the owner of the company, the owner of the company is always going to say, I derive independent economic value from this particular information. But to what extent has the owner taken steps to keep it secret? Even if we can prove it's secret, and even if we can prove that the owner thinks it's valuable, we look at factors in litigation like to what extent is this information known even by those within the company. In other words, if this is really top secret information like the Coca-Cola formula, why in the world are we telling brand new employees on the first day of their employment that what this is all about? Is there a good reason to share that information or not? What steps have been done other than that, other than limiting access, to keep it secret? To what extent has the owner of the company marked things confidential, for example? That's the kind of factors that we're going to take a look at in litigation. Other factors that we might take a look at is, to what extent would it take, well, it's easier to think of this in the context of a common example. Employee leaves the company. Montana and most states don't like covenants not to compete. And they're not going to strictly say, if you work for the screw company that makes and sells screws, actually I had this case too, that you can't ever go out and sell screws for a competitor. That's probably not going to be enforced. So the question becomes, can we enforce it through a trade secret? Can we say that the customer information, people that buy screws, is confidential? How about the quantity of screws and the types of screws they buy on a yearly basis? If someone were to try to put together a list independently of who is buying screws, for instance, how much money would it take and effort would it take to figure that out? And to date myself again, the old days we would say, can I just look in the phone book and try to guess who's going to want to buy these things? Now it is, can I just look on the interwebs and try to figure out who in the world would want to, likely purchase these in my area? Is that something that's easy to prove or difficult? Pricing information, customer information is the most common thing we see claimed as a trade secret in Montana, not always proved out. In the instance of who buys screws, I think I could figure that out, and I'm not in the construction business, but I think I know who might be the large purchasers of wholesale screws. At the other end of the spectrum, case I had many, many years ago, we've got the CFO of the company duplicates our products on a copyright issue that's independent of this, but then also takes customer information and happens to duplicate the exact products that had the highest margin and the most sales, and he knew exactly where they're going. And these were the subject of weekly reports provided to the private equity owners of the company that ultimately controlled the thing. Someone went out with a lot of data that's difficult to find and used that data. That's more likely to be protected than, trying to figure out who sells screws retail, for instance. A benefit of trade secrets is in theory, they can be protected indefinitely. So compare this to a patent. If you have a composition of material, call it the Coca-Cola formula. Coca-Cola could go out and get a patent, or they could have within 1 year of coming up with it, on their chemical composition, or they could keep it trade secret. They can't do both. The trade-off with the patent is a limited monopoly in exchange for ultimately disclosing it to the public. If it's kept as a trade secret, on the other hand, it can be kept indefinitely. And that works pretty well for the Coca-Cola company. It doesn't work well for anybody that's selling a product that can be easily reverse engineered. What are some of the reasonable efforts you can take to protect the confidentiality? Obviously, having employees sign a confidentiality agreement, conducting exit interviews with employees, if possible, to get their buy-in that they know they're subject to these agreements, conducting training on how to handle confidential internal information at the business, isolating the information to allow only certain individuals to have it. You can try to protect it with non-competes, but like I say, normally we see this as an alternative to that. Advantages of trade secrets are obviously there's no filing, no registration. On the front end, that looks really inexpensive. The potential that the rights exist in perpetuity, again, that looks very appealing on some level. And it provides protection by anybody who misappropriates it. Now, if someone independently comes up with the same thing, it's not strict liability like patent law. They have to actually have access to it and use the information in a way that's detrimental to the company. But it comes with a lot of responsibilities. It takes a lot of effort to keep things secret, especially if we're talking about something that can't be guarded like a soft drink composition. It can be a real challenge to the trade secret holder to try to keep those things secret. I'll ask before we move on, are there any questions so far on what we've covered? I've been rambling on now for quite a while. And hearing none, I'll continue with my rambling. Briefly, some things we did not cover, some things we may cover coming up in the other presentations. Special trademarks, there are so-called certification marks. These are types of marks that are used, think like the Made in Montana mark, not the words Made in Montana, but the little logo and the whole thing, or some sort of a certification by some, lately you've seen a lot of green organizations, sustainable organizations, organic organizations certify things. We didn't cover any of that. In the wine area and food products generally, but particularly wine, there are all sorts of regulations specific to that industry on how things need to be labeled. And the reason I tie them in is because they do relate to trademarks. They're a designation of origin. There's certain requirements that a winemaker has to meet in order to say it's made here. False advertising, made in USA. We've seen these cases in Montana. They arise under the same statute as the Trademark Act, as the trademark infringement claims. and as do other types of unfair competition. But and the reason they do is it's a false designation of origin. It's you're not using the word McDonald's to identify the specific source, but you're making a claim that it's made in the United States. If in fact that's untrue, it's a very similar concept to trademark infringement, only it's an infringement against the entire industry that follows the rules. There are other types of intellectual property that come up rarely. So-called software mask works for integrated circuits and types of chips. Boat hull design registration has its own process for registering. It's similar to copyrights. I've worked on a couple of those, oddly enough. There's a vague concept of moral rights that exist at common law related to copyrights in certain states in particular. Rights of publicity, personality, privacy, these all get tied together. California has specific statutes on this, and Montana has constitutional provision, but no specific statutes. What this means is you can't take some famous person, which is why it originates in California, and put them on, the side of your product or in your advertising and claim that that person is, somehow sponsoring your product. You can't try to use them to leverage them without paying them money or something if you can't get Wilford Brimley or whomever to sell your life insurance. And the final one, at least on this slide, is plants. It can be covered by plant patents only if they are certain asexually reproduced plants. We also have the Plant Variety Protection Act. It's a statutory scheme that covers other plants, including certain types of sexually reproduced plants. Not something that I've seen come up often here. We've also not covered other types of, and some of this we're going to get into in the next presentations, but other types of intangible property, business license, liquor licenses, entitlements. If you've got a subdivision with certain amenities and certain rights and everything else, those entitlements would be treated generally as, conceivably as an intangible right that attends to the real property or maybe doesn't. We've not talked about how we transfer any of these rights, or whether that be by licensing or assignment, diligence in purchasing products, or purchasing a company, for instance, that has intellectual property issues or rights, litigation, as well as remedies and damages for litigation we'll talk about next time, strategies for what makes sense to protect, what doesn't, employee issues like covenants not to compete. That concludes the bulk of what I have, but I want to, given we've got just a little bit of time, I want to go through a couple of just interplays of how intellectual property, one type might relate to another type, because these don't exist in a vacuum. It's rare that you have someone that only has a patent and doesn't have trade secrets, for instance. So just to try to interplay a few of these things, I'll fly through them given the time, but first hypothetical, a company wants to acquire another company. They want to sell a pet product. Their options are to buy the company or to buy the intellectual property assets of the company. So what are the next steps in this business transaction? It's simple. The target company makes a unique product that's being sold and they're about to get acquired. The next steps are to figure out, well, what exactly does the seller have in terms of intellectual property protection? Is there anything there that can be protected? What should the seller have looking at this? Well, they probably should have a patent on the product. If the reason to buy this company is a unique pet product, the acquiring company could simply make that product, knock it off if there's no patent on it. Should they have a trademark on it? Maybe. Copyright? No, not if it's a functional product, no, and nothing if it's trade secret if it's sold retail. Well, this, like a lot of hypotheticals, is based on a real situation. They had no patents on the product, so now what? Why does the acquiring company want to pay anything to buy a competitor to purchase a particular product if they don't have any rights in that? Is there a trademark on that product? And if so, how valuable is that? Are there any other reasons to buy the company? Do they make this pet product as cheaply as possible? And for anybody that cares the outcome was there was no patent in this case. There was no reason why the acquiring company should pay a premium to sell the same product as the target, and the deal never went through. The purchasing company decided not to buy the target company because there was no, they had no rights to sell, essentially. One more hypothetical on copyrights. Let's say our client is an artist. Artist has done a very simple pen and ink drawing for a third party. The client has, artist that is, registered a copyright on the design. This is how it normally works. The artist creates a design, even if it's commissioned for someone, the artist retains the copyrights. That includes the right to create, the right to display this work publicly, the right to duplicate it, etc., unless it's specifically agreed otherwise. And now we have the same design used by somebody else. Our client here was Bob, and my issue there. What is it? What are the issues we're looking at? It's you know, are the elements of the design sufficiently original that they can be subject to copyright protection? Let's assume that they are. And then the next thing is, do we care that Bob gets rid of the original canvas? He doesn't own the canvas, he gives it away to someone because it's commissioned. And do we care what the canvas looks like? Because in our facts, do we care that Bob's design is actually a tattoo around Mike Tyson's eye? And the answer is, that's absolutely registrable as a copyright. It's not owned by Mike Tyson. It's owned by the tattoo artist in this case, and it's infringed by the Hangover 2 movie when one of the actors is using that tattoo. Litigation ensues, and it doesn't matter that the money is not going to Mike Tyson, it's going to Bob. And the question is, Bob is the artist, what's the tattoo worth? You know, and what are the damages? Do they get actual damages? What, you know, was Bob really injured by someone else copying the tattoo? Did the other party profit from that tattoo? And if they didn't, why did they use it? And the answer is they obviously did. More importantly, the remedy here is potentially an injunction to prevent that movie from going forward. That's worth a lot of money to the infringing party. So these things can arise in different contexts, and that was the point of these first two slides. With that, I guess I will conclude for the day and ask if there's any other questions that we want to address. I apologize, I can't see into the chat if there is one, but.
If you guys think of any questions for Shane, there are 2 more sessions of this series, so you guys can definitely ask them next week. Just be thinking about them. Thank you so much, Shane, for giving us that presentation. Again, the 2 other sessions will be next week on the 27th, and then the following week on November 3rd. So make sure you guys are registered for those and will be able to attend. And also a recording of this workshop will be sent out to all the attendees next week. So if you need a refresher on anything, it'll be available to you. And please take the survey that will be sent out with the recording. With that, Shane, do you have anything else for the group?
I do not. You can reach me by email, or I think my email is on the thing, or telephone, I think is on the, well, it is on the final slide here, but always happy to answer questions.